funny, our bylaws actually talk about proxy voting, or prohibit them, actually, but good to know. We're gonna need, I think we'll need to vote. We're rolling? Okay, so we have two just mostly housekeeping bits of business to do. Andrew, I know you wanted to say a few words about the order.
Yeah, I don't, yeah, I think we're fine, because you didn't adjourn the okay,
no,
so we still have the quorum.
Yeah.
Okay, so it's all procedure, and there's nothing earth-shattering here, but, so I sent out to your, emailed out the proposed language. So we're doing two things at the vote. We're doing whatever the board determines are the preliminary adjustments, but at the same time, we're adopting the template or the boilerplate of the language that I sent around. So, and there's copies in your folder, so you're welcome to take a look at that. Basically, what's been changed from the current order that now exists are the dates are updated to represent the time period of this coming order from October 1st, 2023 to September 30th, 2024, where it would indicate that those are adopted. They're now proposed in the language. Where it said Order 54 is now Order 55. And so other than that, it's pretty much identical language. So so when I ask when whoever, puts forth a proposal, that you understand that everyone's voting on that proposal of the adjustment as well as adopting the language. So that's how we've done.
Great.
There's no particular, if you have something you want to propose, you propose it there. There's nothing you have to tell us previously. It can all be done at that meeting. Traditionally, we've just switched year. The tenants get an opportunity to put the proposal forth first. Last year, so then we traditionally have switched, so this year it would be the owner. Folks have the opportunity to put forward a proposal first. I believe Nestor, who's in charge of the order of how the meetings run, he's fine with that, correct?
It's fine.
Okay.
As long as it's
so
consistent with how we've done it in the past.
we'll hold with tradition. So, so that's how it works. So that way, unless what the owners propose passes, then certainly the tenant side would get their chance to put forth. And that's the idea, is that both sides are heard, and if that's how it works. So that's how it will work. And then our bylaws say there has to be 5 yeses. So the first proposal that gets those 5 yeses will be what the proposed adjustments are. So does anyone have any questions on how that works?
Yes.
And then we're doing it for both hotel order and the apartment order. The apartment order has guidelines for apartments loft and the special guideline and decontrol units. For those who are new on the board, we're subject to units coming out of rent control are supposed to be going to stabilization. There's that guideline that we're setting is one tool that the owners can use to adjust the new rents and stabilize units. They're also, my understanding is still the case, is that they're allowed to use rents that are similar in the building to help with that, setting that new lease. It impacts about 200 units a year, 200 to 300 units a year. Not a lot, but it's something that we have to do. The current one is 27% above the maximum base rent, and that is simply the difference between what the rent control median rent is and what the rent stabilized median rent is in the 2021 HVS, and that's what that number represents. So if somebody else has a different idea they want to put forward, for whatever reason, you're more than welcome, but that's where that number derives from, and so just everyone has that understanding. So, and that's all part of the apartment order. We'll take that all as one vote, and then the hotel order will be for all those 5 different classes of hotels. That's the only thing we're setting in the hotel order are those adjustments. I believe the agenda will show that we're taking the hotel orders first, and then we'll move on to the apartment after that.
Great, thank you. Any questions?
In terms of process, so,
Sure, put your mic.
let's say there are multiple proposals, which there may be. Do we vote on each one in some order? How does that work?
It's order that they're taken.
I see. So,
And our bylaws say we follow Robert's rules.
right. Got it.
Great.
Sorry, do you have the, like the history of the, it's in there somewhere, right? But in what you sent around, I think it was the, zip file with all the different tables in it, that has what the range was?
Yes, yeah. Look at Christina. Whoa.
I was just interested in what the largest spread was.
We've done spreads in the past of 3% in between. That's something we might want to think about.
And the justification, the idea behind the spread, it wasn't always the case, is that we're not done. We hear public testimony, there's more data coming onto the board, and that's something that was adopted in the beginning of this century. I love saying that. So, and it's continued, and that I think is a rational basis to go forward if folks still want to use the range. The only year we hadn't is the year of the pandemic, and it was 0% and 1, and that's what it ended up. We put a actual number out there, and that was what the final guideline was.
We've done ranges for quite a while now.
Quite a while, yep.
So I think I asked this last year, but I think I forgot the answer. So does the final number have to be within the range, or have there been years when it has not been within the range?
My response to that is it's always been within the range, okay? But if there's data that comes to light or something that really significant happens, it's not, it's not that it couldn't be, I guess. But the idea of a range and a public comment is you want to be able to give somebody that's coming to testify, you're testifying on a certain range of possible adjustments. So if it changed to something that was well off what the range was, then we may have an issue. If it's just outside the range, never happened before, but it would be the degree that it was outside the range. I think that would be the issue, whether people really had a chance to comment on it. Yeah, the only caution there is the larger the range, the less what are you commenting on. So just keep that in mind too. Like, side, Matt, I know it's like the MTA will have adjustments from 0 to 25%. And you go to comment on that, that's a huge range. So what are we actually, hearing on? And so that's just a word of caution with that. To have a 10-point range or something like that, are the public really being able to comment on what the board's doing? But just so bear that in mind.
Thank you. It's a great question.
Twice in 30 years was it below the range. And normally it's within the range, like 90-something%.
But it was barely outside the range, correct? Yeah.
Any other questions? Thank you, Andrew. So just briefly, and then we'll get started with our afternoon testimony. We've talked a couple of times about the mix of hearings and how we want to approach that. Andrew has done some great work putting together possible venues, so we're now, I think, at a point to bring this to a close. I think we have, some consensus that 4 is the right number. It's what we've been doing for many years. We have venues lined up once we reach agreement on this or once we resolve this in northern Brooklyn, in Queens, and in the southern Bronx. And I think the one question where I don't know that we have consensus, and I just want to put it back on the table, my view hasn't changed, but which I'll share again, but I completely respect alternative views. That's why I wanted to kind of bring it to a close, is that I think one of the lessons coming out of the pandemic is that access, obviously being able to be in person is critical, it's important. It's great we're able to come back and have that opportunity, but I also think the opportunity, because not everyone can make a meeting on a school night or a work night, and generally those are the evenings we're going to be meeting, having the ability, and it's great, we don't have to do this all online, but having the ability to have one opportunity for people throughout the city to be able to join us electronically, I think is something that brings our work to a potentially larger group. I think, obviously, these are all hearings that would happen in June, so there's plenty of time to make sure that if people really feel strongly about being there in person, they have the opportunity to do that. And I think all three venues, particularly the one in northern Brooklyn and southern Bronx where we've been before, are accessible to southern Manhattan, northern Manhattan. And Adon, obviously we want to hear from you, but what I want to propose for the board is that we do 4 meetings, 3 in person and 1 remote. So Don?
Yeah, sure, thanks.
Sorry.
No worries.
But we can shut the window, hold on.
Or hopefully they'll move past.
Yeah,
Yeah, it's nice to have a little air for us. Sorry, please go ahead.
no worries. Yeah, I appreciate the suggestion. I agree that I think we should have 4 hearings. I'm sure unsurprisingly, my position and Hennessy's position on this is that we should have all 4 hearings in person. The one in Manhattan, we even heard testimony earlier today from Ms. Delsenia Glover about the importance of having a hearing in Manhattan, and particularly, I would even suggest, why not look in Harlem, like she was saying. I think that it's really important for the public who are going to be affected by whatever adjustment is made, that they have an opportunity to be seen and heard. And I don't think that knowing what we know about people's access necessarily to internet or savviness, frankly, I don't think it's particularly fair. I think if there was an option to have a hybrid, I think that could be beneficial, but I do think that it's important to have public face time. And I also just want to note too, I understand that the policy at Cooper Union, because that's where the preliminary vote is going to be on Tuesday, is that like they have their own COVID policy, which I frankly think is kind of like not necessary at this point, but that's just my personal opinion. I do think it's going to have the effect of keeping folks out who would be testifying, right? And so I just want to be mindful again of like procedures and protocols that we're putting in place that have that impact on people who want to come out and be heard, but also just the opportunity generally to be heard. So our position would be to have the 4th in person.
If I can sort of respond to that, I also feel that it is important to allow access for as many people as possible, and I have the flip response or reaction to remote meetings because I think it helps a lot of people who are disabled or have access issues or have childcare issues to attend, and I think that's also really important. As someone who has to arrange a lot of childcare to attend these meetings, I can tell you it can be an issue.
Thank you, Christine. Any other comment? Doug, please.
Again, question. What was done in 2019 before the pandemic?
Yeah, so we had 4 in-person hearings in every borough except Staten Island,
So there was no.
which we have
So at
never
that point, there
done.
was no ability to have remote access.
Correct, and actually legally we weren't. Legally we could have done a hybrid, but I don't think legally we could have done just all virtual.
And
But
then
now
during
we
the
can.
pandemic, it went full.
Right, and then sort of evolve slowly back.
Last year we did 2 in person and 2 remote.
Do the meetings get streamed?
All the meetings will be live streamed.
So they'll all be live streamed?
Yeah, that's the one thing that we've adjusted this year, and I think people appreciate is every meeting that we're holding this year is live streamed, which was not the case in the past, before the pandemic. So.
Yeah, I take Christina's point about access issues, particularly childcare issues. One thing I also wanted to follow up from what Adon asked about is what is our format for hybrid meetings? Do we have a structure so that some people can ask questions virtually? I believe we had this set up at previous hearings.
Right, so we don't have a structure set up yet for any sort of hybrid. So that'd be something that we would have to work through. So we don't, currently have a plan for hybrid.
Back to Doug's kind of question, how many years were we doing 4 public hearings in person?
So I think it went back, Andrew, you told me the period, we used to do one meeting, and then we used to alternate between one meeting in Manhattan and one meeting in the outer boroughs. And then I think about 10 years ago, we moved to 4 meetings, from what you told me. So it's a relatively, in the 54 years of the board, it's a relatively recent innovation. Again, I think 4 is the right number. I do think having the opportunity is really important, but it has evolved over time.
Yeah, that's pretty much. Back in the day, we did 2 hearings that were much longer, both in Manhattan. And then in the 2000s, we started to do 1 in Manhattan and rotate each year to the outer boroughs. And then in 2000, I guess it was 2013, we started the 4 in each one of the in person. I think it was 2013, if not 2014.
I guess the Zoom hearing would be open to anyone. They don't have to be in the borough
That's right.
designated.
Right, which is true with all our hearings. Anyone can come for, obviously, if you live in the Bronx or Brooklyn, or most likely you're going to go to that, but, well, there's no restriction that anyone can go to any hearing.
Having done too many community meetings by Zoom in the last few years, what will be like the structure? How will that work? Do I have to sign up in advance to testify? Can I just
Right, so,
unmute myself and start to
Right,
do
so this
something?
is-
How's that going to work?
yeah,
in
so this is
practically?
how we're moving forward, because we've made the adjustments. So we encourage you to sign up ahead of time, which you can do by either calling our office or going online and signing up yourself right online. So there'll be those 2 options. That closes the day before the in-person hearing, so, because we have to actually organize the list of speakers and all that stuff. But you still have an opportunity when you come in person to sign up between the period of when the public hearing is stated for. So we went back to the times that were in 2019, all the hearings were 5 to 8, but we stay until all registered speakers are heard. So in some boroughs, that will end at 8 or 8:30 or 9. Some that will go longer, but we're committed to stay there to the people who sign up. So you have that 3-hour opportunity to sign up. So you have in-person possibility of signing up, and also pre-registering, what we call pre-registration. With a virtual hearing, it's pre-registration, but what we've done in our virtual hearings is after everyone's been heard, that's pre-registered, we then open it up for anyone who's there, who would still like to speak. And, you'd basically raise your hand, and we take them in the order that folks raise their hands. So it is never our intent we want to hear from everyone. We try to do everything we can to hear from everyone. The only time restriction we have is venues eventually close. And that's reality, and there's nothing that's a little bit out of control, but we base it completely on what we know has happened in the past, so we schedule times that are going to go over what people have done in the past. So we try to account for that as much as we possibly can, but that's really our only restriction, and we want to hear from everyone. So, and that's our intent. So to sum up, pre-registration online or by calling, but if you go to an in-person hearing, you can sign up between the time period of when the hearing was advertised for. So you can still sign up there. Everyone gets 2 minutes is our time period for 2 minutes to speak. So just throw that out there.
Good, thank you. All right, I think this has been a really good conversation, and I think we've been talking about this for a couple of weeks, and I know Andrew has a lot of logistics to work through if we can resolve it. So I guess I would move for the proposal I talked about at the beginning, if we have a second. 3 plus 1, yes.
Yeah, I'll second that.
Okay, so everyone in favor, we vote by hand, right? This is my first vote. So in favor? So 1, 2, 3, 4, 5, and then opposed or abstention? Oh, 6, sorry. Okay, thank you, Adon. Okay, great. I really appreciate it, and we can talk more. Thank you.
So there are some dates that we've thrown out there, or that for your calendars. So June 5th would be the Bronx hearing at Hostos, which we've been going to for many years. They're very welcoming there, and it's a very large space. Jamaica Performing Arts Center in Queens would be June 8th. We've been going there for about 6 or 7 years. It's a wonderful space, and they're very welcoming to us there as well. June 13th would be the virtual right now. And then we'll end in an in-person hearing on June 15th, and that's going to be at the new St. Francis College location. They have a brand-new auditorium there, so we're going to be going there. In downtown Brooklyn, yep. So, yeah, so I had sent an email with dates. On Tuesday, I did 5, 8, 12, 14. It's actually 5, 8, 13, 15 now because of the logistics we are having with getting the venue in Brooklyn or whatever, so.
Thank you. And if you could follow up with more details.
Nope, I'm only telling you once, that's it. No.
Sorry, I know you'll follow up again, but could
I
you
will
just
send
repeat?
that around. I'm sorry?
I know you'll follow up, but could you just repeat those dates one more time?
Sure, yeah. So June 5th in the Bronx. June 8th in Queens. June 13th would be our virtual. And then June 15th would be the Brooklyn hearing. And they're all scheduled to go from 5 to 8.
The 15th, yes,
15th, right.
from 5 to 8.
Nope, and I'm sorry, and again, I threw that out there, and
And I will just say thank you all in advance I know it's an evening, but it's really important, and I appreciate everyone's.
yeah, and please, like I talked about earlier, that they're going to go past 8, so just to let you know, in most instances, they most likely will go past 8, and some go longer in certain boroughs than others. So,
Okay, great.
just tell you.
5,
5 to 8.
yeah.
We try to get the folks that maybe need to work at night, so we
Sure.
start a little earlier, knowing we're going to go later anyway.
Good.
So we try to give that
And
space.
Andrew,
for
thank
them.
you for all your work getting this.
Yeah, I'm the one who announces it, but particularly Charmaine did a ton of work trying to get this stuff together.
So Charmaine, thank you. So why don't we get started? And if I could ask Michael Topman and Kelly Farrell to come from the Rent Stabilization Association. And sorry for having you come a little bit early, and then we decided to go ahead and get a little bit of business out of the way, but thank you for being here, and we look forward to your testimony. Thank you.
So in talking with the groups that
Yeah.
are testifying, their preference is to all sit at the table at once, so that if questions come, they can feel.
Great, sure, that sounds fine. So that's a great idea. Why don't we, Andrew suggested, and I think it's a great idea, why don't we just have everyone introduce themselves, just so that if there are questions that come up, we know with whom we're speaking. Thank you. So Kelly, why don't you start?
Hi, Kelly Farrell.
That means it's a hot mic.
Great. Kelly Farrell from the Rent Stabilization Association.
Michael Tobin, also from the Rent Stabilization Association.
Basha Gerhardt, Senior Vice President of Planning with the Real Estate Board.
Hi, I'm Ann Korchak. I'm the board president of SPONY, the Small Property Owners of New York.
Joseph Condon from Community Housing Improvement Program.
Great. Please begin.
Great.
Thank you.
Good afternoon. My name is Michael Tobin, as I just shared. I am the Membership and Communications Director for the Rent Stabilization Association. With me is Kelly Farrell, who introduced herself already, RSA's policy analyst. Thank you for the opportunity to present testimony on behalf of the Rent Stabilization Association. I would like to start by sharing thanks from our over 25,000 diverse members from every neighborhood and every community in the 5 boroughs and beyond. Our members own and manage over 1 million apartments. The majority of our membership own buildings with between 6 and 20 units. The next largest group in our membership own buildings between 21 and 100 units. RSA members house New York. We are private providers of a public benefit. All of our members thank you for this year's diligence and focus on the plain numbers and economic data. Thank you to the members of this board, and particular thanks to the board's professional staff. New York City stabilized buildings are facing an insolvency crisis as a result of factors each impactful on their own, but when taken together, as they are now, are devastating. The current reality of stabilized buildings is not enough income, failing to cover ever-escalating costs in an unsteady economy. As we will also state in our later written submission, the data and information provided by the RGB in their 2023 income and expense study, the PIOC, and the mortgage survey fairly and accurately present the economic plight of stabilized building owners. As such, our testimony today and our later written testimony, we will incorporate by reference now and in our later submission the information included in the reports that this body has issued. For example, what we will be providing, however, is information not yet fully discussed or that which needs to be fleshed out. For example, there are at least 24 government mandates with costs attached that are not included in the PIOC. Each of these regulations requires compliance. None of them are optional. All of them have costs attached. These costs include, but are not limited to, additional labor, professional services, tens to hundreds of thousands of dollars in plumbing and wiring and remediation and brickwork, administrative time, and legal fees. These compliance costs add up and are a regular, repeating, and always increasing drain on building income not considered in the PIOC. At this point, I could list 24 of these, but I will not, but everyone is well versed in them. They range from Climate Mobilization Act compliance, the gas piping and facade inspections, and lead hazard reduction, bed bug history, Section 8 processing, FDNY notices, and et cetera. But I think everyone here is well aware of all 24 of them. This board has heard testimony and reviewed information about the coming crisis of mortgages coming due on multifamily buildings. RSA can add to that by sharing information received from the Mortgage Bankers Association in response to an inquiry we made. They recently released the results of their annual survey of upcoming commercial and multifamily mortgages. This survey collects information directly from loan servicers on when the loans they service mature and conservatively model due dates and broader market exposure. The analysis from the MBA estimates that of approximately $4.4 trillion of outstanding commercial and multifamily mortgages, $728 billion mature in 2023, with another $659 billion maturing in 2024. These are national numbers, but New York City, having among the most multifamily buildings in the country, is especially vulnerable to disruptions and turmoil in this market. And that would lead to further economic stress on owners, as refinancing would be at a much higher rate than loans coming due. And these higher rates have been steep, quick, and across and about all parts of the national economy. This is particularly interesting. Concerning data about core Manhattan, which I know we have been intrigued by and been struggling with trying to understand, as I'm sure everybody on the board has been. We have come to consider that several complicated factors impact core Manhattan numbers and distinguish this area in New York City, this part of New York City, from other neighborhoods in which RGB data stays otherwise consistent. So consider these: ground floor retail spaces with significantly higher rents, restaurants, large stores, and chain brands; ground floor medical and professional offices that rent at higher rates than in the boroughs; the prevalence of off-campus apartment housing in areas around NYU, Columbia, FIT, the New School, Pace, JTS, and others; RGB data not including smaller buildings, especially the 6 to 10 unit buildings in neighborhoods throughout Manhattan; housing for patient families, medical students, and other professionals attached to the East Side Medical Corridor; 80/20 buildings with units fixed at preferential rents, short-term rentals, and the impact of assistance programs such as the Paycheck Protection Act, Resilience for Theaters and Pandemic Restaurant Aid, and others in the somewhat closed, tourism-dependent economy of core Manhattan. Again, distinguishing it from the outer boroughs in which RGB data has remained consistent. And when we look at upper Manhattan, for example, the numbers are similar to Brooklyn, Queens, and the Bronx. Concerning housing court, COVID, ERAP, court understaffing, remote technology concerns, right to counsel shortages and delays, moratoria and stays, all of these have closed off access to housing court as a venue where problems are solved. Technically, housing court is open, but for all intents and purposes, because of the criteria and factors I just listed, it is effectively closed off. There has been no eviction tsunami. This is a headline-friendly soundbite that oversimplifies and misleads. Evictions are down everywhere. And when they do happen, again, only a small fraction compared to 2019 and earlier, case duration for non-payment proceedings was on an average of 18 to 19 months, with an average of 6 to 8 months in arrears when the case was commenced, and by the time of resolution, the total number of estimated arrears more than tripled to between $32,000 and $42,700. Housing court, again, is where problems are solved, where tenants are connected to programs they need and deserve, where settlements are reached. Often it is only in housing court that the parties involved can have productive conversations or meet at all. Access to housing court curtailed to the point of effective closing also severely limits owners' abilities to maintain income. This board has been discussing and is considering insurance costs, which is very important. RSA would like to provide further context. The number of mainstream admitted carriers in New York has plummeted. These are carriers that typically have lower premiums and more robust policies. Underwriting guidelines have forced carriers' exits from New York City's multifamily market and more generally away from insuring apartment buildings at all. Building policies from those insurers who will still cover New York City buildings have increased in costs between at least 30 and 40%. Supplemental umbrella policies have increased 300 to 400% while providing less coverage if they're at all available. Insurance carriers see increased economic risk for apartment buildings, and there are reasons here. I won't get into each in detail because we're familiar with it, but I'll just list concerns about disinvestment in buildings as a consequence of the 2019 HSTPA, replacement costs, which is the price of everything to cover claims, has gone up, empty apartments. These units are vacant because desperately needed repairs and improvements are unaffordable. This forces owners, depending on the size of the building, to get partially vacant policies, which are more expensive. And then they feed the downward spiral because then there's less income to invest in the buildings, which means more apartments stay vacant, which require an even more expensive vacant policy. COVID years saw an increase in personal injury claims against buildings, and without editorializing on the appropriateness of individual claims, the data shows that it is indisputable that the quarantine and the COVID economy encourage plaintiff claims. And of course, weather-related claims, which impacts everybody in coastal communities and are always awful. I will end my testimony on behalf of RSA's diverse membership as it started, thanking the members of this board and its professional staff, and thank you to my colleagues for other owner organizations for their partnership and their diligence. I look forward to hearing from them, and then we'll be available for any questions.
Thank you. Let me open the floor for any questions. Doug, please.
Thank you, Michael, for your testimony. I want to make sure I'm understanding, because maybe I'm not. I'm, I guess, the newest member here, so. Your discussion about Manhattan Core, obviously the data that was presented by the board, by Andrew and the staff, showed significant declines. I think I heard you sort of say that that's mitigated by a whole bunch of factors, right, including all the factors you raised. So is that what you were trying to say? That we should not, as we're thinking about our
core Manhattan,
analysis?
and Kelly, please correct me if I go wrong. Core Manhattan numbers in some instances show higher rent collections in some areas and in other areas, significant loss of other income in buildings. The statistics and numbers around core Manhattan simply are not very
Representative or
reflective
distorted.
of the rest of the city. And
Got it.
to tell you the number of hours we spent thinking about this and speaking with each other and speaking to outside economists and thinking about this, and we realized that it was not a statistical aberration that could be simplified, that it could really only be explained by embracing its complexity and then looking at all these different factors and then thinking creatively about these factors, but not pie in the sky, but realistic. The East Side Medical Corridor is its own housing economy because of patient families and medical professionals. Student housing in New York City, given the prevalence and concentration of universities and law schools in this area, is another factor. The 80/20 buildings with fixed units
think-
at pref
yeah, no,
rents,
I hear that.
short-term rentals, again, not editorializing on that. So it's
So are you
simply
sort
to
of
encourage
suggesting? that-
Brooklyn, the Queens,
Right.
the Bronx.
I mean, what Andrew and the staff do is they take out core in a lot of their analysis. You're sort of saying that makes sense.
Yes.
And I think that's actually something where both the tenants and landlords are agreeing, from what I have heard. That is distorted data, and we should not really think about that in the so am I getting that wrong?
I wouldn't think of it as distorted data. When Joe's going to go next, but I preview the development history of when you look at the development history of New York City and you look at the zoning for New York City, larger buildings are encouraged in core Manhattan. So therefore, it is not a surprise to see an overrepresentation of larger buildings as compared to smaller buildings. And it's not to say that these numbers are not true. You also have, I would say, an over-reliance on tourist economy, on student housing, on retail rents. Retail rents have not recovered to pre-pandemic levels. We're seeing market rate rents have not recovered to pre-pandemic levels within core Manhattan either. I think what we hope to impress upon the board is core Manhattan is very complicated on a slew of different factors and variables. It's not to say what you're seeing is not a statistical anomaly. What you are seeing is a very unique set of circumstances that creates data that is different than what you see in the rest of the city.
Thank you for that. So not statistical anomaly. It is an overrepresentation of the larger buildings and an underrepresentation of the smaller buildings because not counting anything below 11 units, correct? So, yes. Thank you.
So I'm interested in your comments on the insurance costs. And one thing I'm trying to figure out in particular is the extent to which the increases in insurance costs in that area. It seems like everyone does kind of agree that there have been increases in insurance costs, but I'm curious the extent to which these are sort of transitory or more persistent and ongoing drags on building expenses. So you kind of touched on, I think, a few of the driving factors, including loss of exits of insurance companies from the area, maybe remediation costs for buildings themselves, as well as climate-related factors. So I guess I'm just kind of curious if you could just discuss that issue a little bit more.
We believe it is not a transitory situation. We believe that it is the new normal of spiking insurance costs. Insurance companies, insurance by its very definition is spreading risk, right? And without, given the climate, for the reasons we discussed, insurance companies stop seeing coverage here in New York City as spreading risk and saw it more as simply a payment mechanism, which is not the business they're in. The 2019 HSTPA curtailed investments in buildings that insurance companies insist on as a matter of course, whether it's IAIs or MCIs. It is also the climate that was around the discussion of the HSTPA that scares away insurance companies from the New York City market. Insurance companies look at their balance sheets and look at this market and their economy in over decades, and what they see is something similar to policies that encourage disinvestment from decades ago. And that because insurance is about spreading risk, those are not risks that they are willing to cover or absorb, which forces not admitted carriers, usually outside the immediate region, that provide policies that are less robust and pricier. The replacement cost piece is about inflation and supply chain disruptions, and that impacts all economies. all segments of the market. The empty apartment aspect requires coverage that is more expensive. The litigation piece, the personal injury claims, simply we got from OCA data, and then, of course, the weather-related. But those were the main drivers that we saw.
So I just had a question. You mentioned like the student housing being different in Manhattan. I'm a little confused how that is, why it's different, especially given that there are so many colleges in the outer boroughs as well.
There are, and I can actually speak to this with some authority. I serve on the board of some SUNY colleges, and the colleges in core Manhattan tend to be considered premier destinations and ones for whom students travel from throughout the country. While my father and his sisters are proud graduates of Brooklyn College, I don't see people from out of the Mid-Atlantic region moving to Brooklyn to attend Brooklyn College. The colleges in downtown Brooklyn, which I believe has more universities than Boston, are generally, with the exception of Pratt, not all the time destination colleges, Brooklyn Law School being an exception. But again, that would feed into the, what Brooklyn College is in downtown Brooklyn actually is what proves what's happening in core Manhattan, where you have these concentrations of Columbia, NYU, JTS, Union Theological, all these sort of premier destination schools that exist mostly only in Manhattan. And again, I'm a SUNY and CUNY graduate myself, and I think there's an enormous fallacy around needing these premier name brand colleges and universities, but that's simply what the economy is. And that's distinguished in Manhattan from CUNY, Queens College, or Brooklyn College, or Hostos.
And I'm just trying to understand, so it's then students coming from farther away are sort of distorting the housing market in.
Yes, and it is, they are distorting, as is the housing along the medical corridor on the east side. Please.
And a function of that is the universities and the facilities do not provide sufficient on-campus housing for the
Right.
population that they are
So
serving.
then you have a population of students who are living off campus.
Exactly.
Part of that, okay.
More so in the New York City metropolitan area than you would. I mean, these schools' enrollment depends on being able to move students off campus by sophomore year.
Correct.
Thank you.
Great. Joe, do you want to go next?
Yes, thank you. I am still Joseph Condon. I am still here representing the Community Housing Improvement Program. Before going forward, I always like to remind the board in the beginning that the buildings owned and operated by CHIP members are predominantly subject to rent stabilization because they are constructed prior to 1974. I think it's an important point to remember because it means the buildings don't receive tax benefits or any other type of subsidy in exchange for their rent stabilized status and providing below market rents. These buildings essentially have to account for all of the operating costs of an unregulated building, but without being able to charge those proportionate rents. So that brings me to my first point, and probably my main point, that this board's annual decisions on rent guidelines really control the fate of the rent-stabilized housing stock. When the state legislature passed the 2019 rent laws, the responsibility to ensure rent-stabilized buildings can continue to operate in financial and physical health was really placed solely on this board. There are no longer mechanisms outside of the annual RGB guidelines to adjust rent-stabilized rents on vacancy, nor receive a meaningful return on capital expenditures for apartment improvements, new building systems, or new building infrastructure. This is the second year we are seeing the impacts of the HSTPA in the data, and the results are pretty clear. The rent-stabilized housing stock is heading in the wrong direction. Even before 2019, this board's rent adjustments have been under what is necessary to keep rent-stabilized units healthy, particularly for highly rent-stabilized buildings. But the shortfalls of those guidelines were able to be masked by other rent increases that were allowed in the system. Now that the RGB is effectively the only rent increase permitted, this board has become the de facto social safety net for rent-stabilized housing providers. Rents have risen over the past few years under this board's guidelines, but NOI keeps dropping because the cost to provide housing is rising faster. when the RGB adopts a guideline that is lower than the CPI adjusted commensurate or somewhere in that range, these buildings are being defunded because there are no other avenues to increase those revenues. Just a couple of points. Distressed buildings are increasing. This is the 5th year in a row, with an increase in that category. Cost to income ratios are rising, and NOI is decreasing, especially in highly rent stabilized buildings. Just taking a quick look at the comparison between 1-year commensurate guidelines and what the RGB has adopted for 1 year. It's on the first page of my testimony. You can see why NOI is down and distressed buildings are on the rise. Also attached in the back, it's on the 4th page after my testimony. There is a sheet. I'm sorry that it's not formatted well. I'm not really good at printing Excel sheets and graphs, but I did provide Andrew the electronic copies so he can share that with you so you can look in more detail. But basically that chart is a comparison of the two measures, the 1-year guideline and the 1-year commensurate for CPI adjusted. It's in a chart entitled Rent Growth, and it tracks the rent of a unit from 2013 using both of those standards. And you can see from the chart that since 2019, the gap really continues to grow, where rents should be for a financially stable building and where rents currently are. While vacancy increases used to be able to close that gap when an apartment turned over, that is no longer the case, and by adopting guidelines lower than the commensurate, the RGB is allowing that gap to continue to grow, while more properties fall into financial distress. Instead, we think the RGB should be attempting to close that gap, or at a minimum, not allowing it to continue to widen, which brings me to my point number 2. We think this board should focus its deliberations on those highly rent-stabilized buildings that were constructed before 1974. We consider, and I think the board does as well, that these buildings are important, highly rent-stabilized buildings. We consider them to be 80% or more rent-stabilized units, and they account for nearly 80% of all rent-stabilized buildings in New York City outside of core Manhattan. And more than half of those buildings are 100% rent-stabilized buildings. These buildings are reliant solely on the RGB guideline, and thus the board should give more weight and consideration to their economic situations compared to other rent-stabilized buildings. We think these highly stabilized buildings should really be driving the discussion here. Pre-1974 highly regulated buildings, they have little to no free market tenants. Many of them have no commercial income, and there's no other way to keep up with operating costs. And this is why we believe that a supplemental memo on the I&E about these particular buildings that was published last year would be helpful for the board again this year. Again, these are the buildings that are fully dependent on the board's guidelines to balance their books. Okay, so while these buildings may not have seen the sudden drop in NOI like core Manhattan, any drop in NOI is concerning in these buildings because, as we have seen, it results in the need for a significantly larger adjustment in the next year. Seeing 2 significant back-to-back drops in NOI over the last 2 years, and 3 out of the last 4 years showing declines in NOI. Those should be highly concerning for the board, especially given the correlated increase in distressed properties over that time. And over time, this type of defunding impacts not only the quality of the building stock, but the quality of life for the tenants as well. We also did a study to try to track cost-to-income ratios and NOI for those for the fully rent-stabilized buildings. That is also in the back. I believe it's the first page after my testimony. Again, it's not well formatted, but you will have the electronic copies. The one thing I just want to call your attention to is the real cost-to-income column on that page. It tracks over time from 2017 through 2021, and you can see that the real cost to income continues, was pretty steady, 2017, 2018, and 2019, and then really started to spike after that. And right now, based on our calculations, many buildings are barely breaking even. So I would encourage you to take a look at that. So looking at these filings, we see that cost-to-income ratios for fully stabilized properties average about 8% higher than what the RGB reported. And looking at post-HSTPA data, the cost-to-income ratio continues to spike, and NOI sharply declines immediately after. So we do appreciate the staff's improved reporting on NOI and cost-to-income ratios as it breaks out newly constructed buildings and the report that contained the pre- and post-74 breakdown. But for the pre-74 buildings, free market units are still included in that analysis, and those free market units can significantly skew the data. The data reported, because the data reported from those buildings, even one rent-stabilized unit in those buildings qualifies them as a rent-stabilized buildings for inclusion in the report, which is why we think you need to look at the highly stabilized buildings. Because otherwise, including the free market inflates NOI and reduces cost-to-income ratio, and therefore gives this board a rosier outlook for rent-stabilized universe than actually exists. Just a couple of points about sort of where rents are now, and where they could go. The median monthly rent in rent-stabilized buildings for 2021, excluding Core Manhattan, was $1,205 per month. Just for argument's sake, an 8.5% increase to begin to reverse the pattern of NOI decreases would result in a $102 per month increase in rent, bringing the new median rent to $1,307 per month. That new rent number is affordable to a 3-family household at 40% of AMI in New York City. That family earns about $48,000 per year, and assuming about 1/3 or 30% of that is spent on housing, the $1,300 per month apartment would be affordable to that family. The median household income for rent-stabilized households is close to that number, $47,000 per year. So it would appear that not only the data calls for a rent adjustment, but there are household incomes in line with the median rent that would result from such an adjustment. And a rent increase along those lines allows housing providers to continue to pay their bills, keep units maintained, and comply with the city's capital expense mandates such as Local Law 97, new lead paint testing and abatement requirements because of lowered lead thresholds, all while keeping rents at affordable levels. We also think that the rent adjustment would be in line with the statutory mandate of this board under the RSL. The statutory mandate is to prevent unreasonable, oppressive rent increases that would cause displacement or disruption. Following the data, it is clear that a rent increase in line with the commensurates would not only keep the affordable housing stock in proper condition and maintain New York City's diversity of ownership, but would still keep rents affordable to low and very low income families in New York City. So just in closing, Chip, we are more than willing to explore reasonable policy solutions to ensure housing is affordable to low and very low income families. We just don't believe this board is the proper place for that discussion. But until the government can reduce the costs of operating rent-stabilized properties rather than adding to them, this board will be perennially put in the difficult position of having to adopt rent adjustments to keep up. CHIP members are very cognizant and concerned about the need for housing for low-income families, as that responsibility has been placed on them by this board every year for decades. This year, our members ask that they no longer be singled out to bear this burden, and for the board to follow their data in their decision. Thank you.
Thank you so much. Questions from the board? Please, Christina, then I have one point of clarification.
Thanks for testifying. I had a question. This question comes up, it was even raised this morning, about that there are programs out there for landlords if there are hardships. There are programs available to landlords if there are hardships in covering costs. Do you have a sense of how many of your members have accessed these programs, and if you think they are eligible but not accessing them. Do you have a sense on why?
So the two hardship provisions that are in the RSL are very demanding. I think one compares the current NOI to what it was in 1974. So if you can't meet that test, then you're not allowed to take advantage of that provision. The other one requires buildings to be losing money for 3 years before they can apply. If that is the board's intent, then maybe you will see more applications tick up. But I don't think the board should really be waiting for an uptick in hardship applications, because at that point, we may be past the point of no return for at least for several of those buildings.
Arpit, please.
Yeah, so we also had a discussion this morning a little bit about sale prices for units, and I'm just kind of curious, what are typical cap rates like for these buildings? That might, because you provide sort of NOI data, that might be another way to sort of triangulate what's going on here as we interpret that sales data.
I cannot speak to cap rates, unfortunately. That's not really something that I'm involved in. If anyone else wants to chime in, but
As the macro picture here. So cap rates, I would say pre-2019 for stabilized multifamily housing was trading at close to 4%. Typically, you were looking for cap rates higher than that if you were talking about new construction or new development. All of those numbers have gone down. We are now a year out of the highest inflation in my lifetime, if not, certainly career, and some of the highest interest rates we've seen in quite a while. So all of these are creating, I would say, on a macroeconomics level, very challenging circumstances. It costs more to replace things. It also costs more to borrow money, whether it's to sell a building, refinance a building, or build something new.
To that, I would add, given the diversity of RSA's membership, we have a presence, for example, in Lower Manhattan's Chinatown. In the run-up to the 2019 HSTPA, there were tenant activists who we dialogued with regularly, who insisted on, I think the term at the time was pass all the bills, right? So, and then the same activists were decrying the loss of neighborhood and authentic and local ownership of these buildings when owners in Chinatown were then selling to corporate interests or REITs with the ability to absorb these increased costs with the lower income. So anecdotally, I reached out for one of these activists who I've known for many, many, many years, and I said, well, which is it? Is it pass all the bills, or is it we have to protect the ability of local owners to maintain their ownership stake? And she said, yes, we want both. And I said, the numbers don't necessarily add up if you're talking about home ownership and how buildings were trading and selling. And she said, well, that's not our problem. And said, well, it's very much our RSA's problem, because these are our members who find that they can't afford the financing to maintain the buildings with MCI's capped and IAI's now unavailable to maintain these buildings at compliance levels. So it's an anecdotal answer to a very technical and macroeconomic question, but there's the macroeconomic, and then there's the lived experience of what's happening again in Lower Manhattan and in Bensonhurst and Sunset Park, where folks are insisting on local ownership and decrying the loss of it while providing no economically feasible means to continue it.
Thanks. I just wanted to go back to actually part of what Christina's question is about. I have two questions. So in terms of the hardship application, I guess I'm just trying to understand, because I think you were saying that, in one of the two ways that you can show hardship, folks just think that it's too difficult to prove, so they just don't apply. Is that what I was to understand?
No.
So then,
I think
okay.
you have the first category where you have to compare to your the time that you bought the property, or some decade ago.
However many decades ago.
Yeah.
But you were saying that your members don't think that they would actually wind up meeting the hardship, so they don't apply, right? I'm just trying to understand.
It's just a standard that no building can meet.
Right, so what I'm trying to get at is, so in both scenarios, that and in the 3-year scenario, right, where you have to show a loss, I have a hard time understanding why it is that a landlord wouldn't even attempt to try and file such an application, because it just seems as though, right, we're hearing this is the only way that we can get increases now post HSTPA, and given the standard or the state of where everything is at. But there seems to still be a mechanism, and there has been for many decades. But if you actually look at the number of applications that have been put in, I think last year was 1 application. So I'm trying to better understand from your membership why it is that nobody puts in any of these applications, even if it's a long shot. Wouldn't they think it's like worth it to try and get the increase?
I think that when you see them having decreased NOI or whatever the requirement is for the 3 years, you may see an uptick in applications. It's, we're only a couple of years past HSTPA. So, I think, DHR is coming here next week. You may hear something different.
Okay, yeah, that's fine. I guess the second question I had is, since again, this idea of just not having available options, last week we heard about HPD, and they were talking about how there's tons of different programs available to assist rent-stabilized owners with things like repairs. Trying to see, there's a list of programs here. There's like the Landlord Ambassador Program, the Green Housing Preservation Program, Multifamily Housing Rehabilitation Loan Program, Participation Loan Program. I know we didn't get a firm sense from HPD last week as to the numbers of your constituents that are taking advantage of these programs. I just wanted to hear from you what general sense of people taking advantage of these programs as I've listed them, what that has been looking like.
I can speak to that because SPONY has, in the last year, had some interaction with the Landlord Ambassador Program and also the New York City Accelerator. And they were staffed with very energetic people, right? Really wanting to help. And, they reached out to me and I said, sure, we better, get a webinar. I mean, we had, 50, 60, 70 people sometimes on a call. But the sense that I got with the Landlord Ambassador Program, so many SPONY members have been at this for decades, right? They're family-run businesses that, oftentimes a parent or a grandparent. So I got the sense that the Landlord Ambassador Program was really better suited almost for an accidental landlord, maybe somebody that had inherited a piece of property and had never helped actively run it. Many of us that were on that call knew as much or more about, upgrades to buildings than the staff there. And that's not to be meant as a criticism, because like I said, they were incredibly professional. They really reached out and they were very well prepared when they did their presentation. I would say the same of the New York City Accelerator Program. I think with the New York City Accelerator Program that they may be overwhelmed, in their ability to really help. 1 or 2 conversations. I had some follow-up emails about a solar program specifically for my 10-unit building, and then it just, we didn't make it much further. So I think that's part of it. And then going back to the original program that you spoke to, the HPD distressed building, I would say that 3 years of loss, if you have debt on the building, or if you have not paid your taxes for 3 years, you've probably already lost the building. So, a 3-year look back is really not going to work for a small owner who is, drowning in debt or tax arrears. And I would say probably like a lot of city programs, there's a lot of complexity, a lot of wait time, a lot of things that just don't progress. And, because we know there's a severe shortage, right, of human resource in every city agency. And, HPD is suffering from that as well. So that's just my experience, from what I've, and like I said, I don't want to be critical of them because I do think the intention is really there to help us. But there's, there's like kind of a gap. The need isn't being met.
Thank you, Don. Rick, please, and then I'll have one last question.
Thank you. And this is actually really interesting analysis. I really appreciate it, but I'm trying to understand, I can read it, even formatting's not the issue. Your sort of underlying assumptions on the chart you refer to about the real cost to income, the analysis you did for the selected subset versus the RGB numbers. Just so I'm understanding, you use tax cessori data? Is that what you took this from?
TC2, yes, you're right, TC2
So
on
it
data.
was sort of selected universe, right?
Yeah, you know,
Yeah, no,
that's
no.
all we got, you know?
Yeah,
So hopefully the board will ask for that I&E memo and you will see a bigger universe there.
Right. I see what you're saying. So
So
there,
I know this is your first year on the board.
It is, it
Last
is.
year, there was an INE memo distributed by staff breaking down pre-1974 properties by their level of rent-stabilized units. And in that breakdown, you could see there were boroughs where the pre-1974 rent was higher than the actual pre-1974 highly stabilized units because of the inclusion of free market rent in that analysis. So
this
that
is,
co-
your analysis, just to be sure, is only for buildings that have 100% rent stabilized units?
correct.
I see. Okay. Thank you. Yeah, it has been, yeah.
The only piece that's missing is the breakdown of the pre-1974 by stabilized status. And because there are differences and because of the free market units, that's an important piece of information.
I always do encourage board members for this, but if you want to look at more buildings that are residential, our cost to rent ratio is a better indication because it's not including those buildings with big commercial. So those on that.
So I included the
even
cost
though-
to rent in there as well.
Right.
So you could see,
Which is,
yeah.
yours is still adjusted higher, but it is closer than.
It does
that's
get
why I
closer,
would-
yes,
yeah.
but we're still not there.
And Joe, just to clarify on this, you had said in the sort of explanation part of the testimony that you were trying to estimate also capital expenditures and debt service in NOI. That's not included here.
If you flip the page over,
Separate chart, okay, I
it's
just wanna
double
make
sided.
sure.
Yeah, flip. If you flip the page over, you. Yeah. So you can see. We didn't chart it out, but you can see. So the real NOI on that second page is just the difference between the gross income and the expense total, and then trying to assume a roughly 25% of gross income towards capital X and debt service. Those are those numbers, and then you could see the NOI per square feet continuing to decline over time until it's negative in 2021.
Got it. Okay, thank you. Other questions? Joe, thank you very much. I think we're to hear next from Basha Gerhards. Thank you.
So much, so I might need some help here. Yes, please. Thank you. All right, setting the mood, I guess, for this. If we can't get it to work, they have the printout, so we can.
Okay. Just wait a second.
All right. Oh, there we go.
Okay.
All right. Great. Oh, I didn't touch it. Okay. All right. So I'm ready to start. Okay. No, it's okay. Just make sure. Good. All right. So also still Basha from the Real Estate Board. The Real Estate Board is the city's leading real estate trade association representing commercial, residential, and institutional property owners, builders, managers, investors, brokers, salespeople, and other organizations and individuals active in New York City real estate. An important part of the housing ecosystem we represent are the owners and managers of tens of thousands of rent-stabilized units. Thank you to the members of the New York City Rent Guidelines Board for the opportunity to provide our perspective regarding rent adjustments for the city's rent-regulated apartments. The annual rent guidelines established by the RGB are the only meaningful system-wide path for financial solvency and therefore housing quality for stabilized apartments. The Federal Reserve conducted a comprehensive study to explore the impact of financial constraints on building maintenance and tenant welfare, which identified a correlation between financial constraints and an increase in code violations for the affected buildings. Furthermore, the study analyzed the effects of statute changes, much like the ones adopted in 2019 that my fellow industry members have already referenced, that reduced the expenses property owners could recover through improvement costs. As a result, a notable increase in financially constrained buildings and a subsequent rise in violations per building were observed, compared to unaffected buildings in the control group. Restricting rents has contributed to a decline in overall building maintenance. Therefore, given the importance of this board's decision, and to help the board make such a decision based on the most recent data available, REBNY, along with its industry partners, commissioned a study led by HR&A advisors to study more current revenue and expense data and change over the last 4 years. Conducted over 3 weeks, the study includes data for the 2022 TC201 data that was submitted through that form. It's also known as the Income and Expense Schedule for Rent-Producing Properties for the New York City Tax Commission in March of 2023. All right. This study utilized over 1,200 owner-provided TC201 tax forms from 2019, 2020, 2021, and 2022, representing over 400 buildings, to examine increases to owner expenses and the impact on income on a longitudinal basis. TC201s were chosen because they share the same fields or categories as the real property income and expense RPIE statements, and because Form TC201 requires certification and financial audit by an independent certified public accountant. TC201 data can also be accessed via commercial server service known as Genesis. However, this data does not include 2023 filings and relies on the fact that TC201 data is made public only for those owners who ultimately appeal their property tax bills. As such, the commercially available data lags by a year and may be skewed as it only represents those buildings who ultimately appeal. We think this is still an exciting addition to the data landscape, and it is new, and we want to continue exploring how this data ties to the building typologies used in the PIOC. Importantly, both this information and that of the current survey of 2022 TC201s are additive to the board staff's own data work, and we thank them for the work they've been doing over the last several years to explore new typologies and access new types of data. By collecting TC201 forms from 2022 and earlier from a cross-section of New York City building typologies, we can provide metrics related to the income and expenses of New York City's rent-regulated housing stock with the most recent data possible, looking beyond the 1-year lag in RPIE data available to the Rent Guidelines Board. Last year, we engaged in the same exercise, showing 2021 TC201 data for the 2022 proceedings, where we highlighted exponential increased costs in fuel and insurance, which this year's RGB staff reports affirmed. The 2022 TC201 data clearly shows that operating and maintaining rental housing has only gotten more challenging, affirming the expense growth trends, especially in insurance and fuel, and the significant gross income declines presented to the Rent Guidelines Board by board staff over the last month. The 2022 TC201 dataset also affirms the income-to-rent ratios across the 5 boroughs from the Rent Guidelines Board. While higher income and rent numbers were found in core Manhattan, this is due to a variety of factors. primarily the overrepresentation of larger buildings with more units and an underrepresentation of smaller buildings which tend to be 100% stabilized. This overrepresentation of larger buildings is influenced by the city's development history, which encouraged high-density residential development in core Manhattan. Much of that development occurred after 1961. Therefore, it is not a surprise to find larger buildings built post-1974 in core Manhattan. These tend to contain more units overall and have more market rate apartments. Another factor is a reliance on retail rents, which have yet to recover to pre-pandemic levels. An additional consideration is the self-selection of those who choose to file TC201s and those who are required to file RPIEs, which does not include a requirement for buildings with less than 10 units. Despite the core Manhattan numbers, there has been a 38% decline in gross income since 2019. The TC201 data from 2022 also shows that all income categories remain lower than 2019 levels, including regulated and unregulated rents. Market rate rents remain 21% below pre-pandemic levels. On the expense side, property taxes continue to be the top expense for owners, while fuel and insurance rates are the top drivers for expense growth. Before I move on to that, I did want to pause here to show all the different income levels and the percentage drops across the board, and those trend lines since 2019. Yeah, of course.
Can I just ask that question about the slide? So are these inflation-adjusted numbers here, or are they nominal?
These are adjusted by inflation. But I do want to confirm with our folks, that's usually how we try and undo this to show the trend lines. We're trying to, present things in real time. Yes, so the 2022 levels are coming from the 2022 TC201s. Which is correct, right. Okay. So, as I mentioned, property taxes continue to be the top expense, followed with fuel insurance as being the new drivers, I would say, of that expense growth. So let's look at that. So fuel costs have continued to increase into 2022 and have risen on average 40% since 2019. Fuel costs are higher on a per unit basis for buildings with 11 to 19 units, which have seen costs rise individually 59%. Insurance costs continue to increase into 2022 as well, rising on average 53% since 2019. Buildings with 11 to 19 units had the highest increase in insurance costs with a 78% increase, followed by buildings with 20 to 99 units that had insurance costs increased 71% since 2019. The increases in insurance reflect the risk in operating and maintaining rental housing in New York City, inclusive of unpaid rental arrears, the cost of regulatory compliance, and financing and debt risk. Debt service and debt risk, or the ability to pay debt service, are additional metrics that should be considered in the determination of any rent increase. First, it is important to note that after expenses such as property taxes, fuel, and insurance, the net operating income must still pay for debt service, capital improvements, and the personal income taxes of the property owner. When it comes to establishing debt risk, the Congressional Research Service states that lenders typically require a minimum debt service coverage ratio, or DSCR, of 1.25 or higher. They also report the loan-to-value ratio, LTV, reflects the initial amount of equity a developer or owner has invested in the property. LTV and DSCR are key factors to predicting defaults or debt risk. That's because when the current property value declines far below the outstanding loan balance amount, mortgages become underwater. DSCR is susceptible to fluctuations during unexpected periods of high vacancy or non-payment. For building owners with mortgage payments, the survey and RGB data shows that building income has been constrained at the exact time that mortgage payments have gone up. This means these buildings don't meet lender metrics for debt service coverage, and their loan-to-value is trending in the wrong direction in that the loan value is higher than the building is worth. Over the last several years, New York City's multifamily rent-stabilized housing stock has experienced multiple shocks, which are adversely impacting revenue and building value, and in turn, increasing the risk for default. These shocks include extended periods of non-payment, as tracked by the National Multifamily Housing Council and discussed in the board's reports, and over a year of volatility with inflation and increasing interest rates. The Congressional Research Service also outlines that multifamily mortgages typically have shorter maturities, prepayment penalties, and adjustable floating rates. Unfortunately, those rates have rapidly increased over a period of time where income has significantly decreased. What this means is that factors such as rising interest rates have increased debt service or the amount owed to the banks at the same time as DSCR and LTV have dropped. Therefore, debt risk has increased as net operating income has decreased. To keep buildings in good physical condition for the people who live in them, we encourage this board to therefore considering the decreasing NOI and decreasing income of the stabilized stock, coupled with the increasing expenses and an increasing number of distressed buildings in its deliberations for the 2023 guidelines. Thank you for the opportunity to provide the 2022 TC201 survey.
Thank you, Basha. Let me open it up for questions. And we have the slide, but we also have you shared with the board the larger study underneath.
Yes, I didn't want to go through all of the methodology and
of
details today, but that was shared as a PDF and is free to be shared with all the board members for
Thank you. I just
to
wanted to make
answer
sure
any
we had
questions
that.
there.
Great. Other questions? Please, Doug.
Can I, just back to this chart that you, the one that we looked
Yes.
at in the slide. The numbers all come from, you said the 2022 number comes from,
The 2022 number comes from the 2022 TCO1, the
prior-
2019 comes from the 2019 TCO1, the
they're all from the TCO. Got it.
Correct,
So they're all that subset of the universe.
correct.
Got it.
And are the same buildings or just a sample every year?
No, so part of the data process here is we received 1,200 forms for over 500 buildings, actually making sure we had 4 forms for a single building to do that longitudinal study. So that was part of our data process and why I'm very thankful to the HRA team for doing this over a very short time frame.
To that question, it's different buildings. It's a,
No. So if this 2019 number represents, and the 2020 number and the 2021 and the 2022 is tracking the numbers for the same universe of buildings, we excluded any buildings we did not have all 4 years for.
got it. So there were 4 years of filings.
Correct.
Got it. So you,
Per
you-
building,
and
right.
that was, how many buildings was it again?
It was just over 400.
400 buildings. Great. Well, thank you.
And just quickly, and then ARPA, just remind me of remind us of the geography of those 400.
Yes, so these buildings are in all 5 boroughs, representing all of the age ranges. If you know, as we have conversations about like future areas for study, I do think it's worthwhile to start breaking out the post-1974 into potentially 2 buckets. You know, I know there's a lot of conversation around tax incentives. 421A is a 50-year program, which means everyone who entered into it in its first 30 years is actually paying full taxes. So this is an area for future study and consideration, and certainly something we would like to, you know, as we can keep thinking through all of this, you know, it's important to have the smaller buildings that tend to be predominantly 100% stabilized. I wouldn't say just our pre-1974, those are really pre-1945, right? Like we're talking about very old, aging building stock here and distinguishing between some of the other costs. That being said, costs are up for lots of different buildings in lots of different ways, whether it's local law 97 compliance or labor requirements. People may not realize this, but in the housing and maintenance code, once you go over 50 units, you're required to have a building service worker for every 50 units plus other support staff. So labor cost may be higher actually in those larger / newer buildings, but again, the math of operating and maintaining housing, especially with stabilized unit, it just continues to get harder.
And to that, I would add that both RSA and SPONY participated in the HRNA study, so the sample of 400 buildings across multiple years is fairly representative of across the board. And we had more responses than 400, but as Basha pointed out, if you didn't apply
Yes.
with all the years for the study, it dropped out, so.
Right, we had 533 buildings, but they didn't all have their 4 forms, so we got it under 500.
Yeah, my question is sort of related to what you were just discussing, which is just what's the selection criteria for the 1,200, forms that are being collected, and then, and then maybe just a little bit more on how you're whittling that down to the 500 that you're analyzing, 500 buildings.
I can tell you the methodology that went into soliciting this information.
Cajoling, begging.
Cajoling, begging, which is why it was important that RSA and SPONY participated so that it could not just be buildings
Of a certain size
of a
and
certain
ownership.
size and ownership. We did this with twice weekly, sometimes 3 times weekly, and I think my colleague Brianna, since she wrote all of these, email blast to our membership. We did it through other connective platforms via text message and email, and we followed up in some cases with calls. SPONY then repurposed these outreach materials for communications with their members, again ensuring a cross-section.
And sorry, just a very quick follow-up. So just so that I understand, so these are the forms that the buildings are already submitting anyway. You're just getting
Correct.
those forms. You're not soliciting additional information. Okay.
Correct. And one of the things I want to note is, and this is I'd say some of the utility or value with Genesis, or even, whatever the board itself is able to communicate through the Department of Finance. There's always a lag in getting forms from government, as I know many of us are very familiar with, and it's subject to FOIL rules. So this is our way to get directly from the owner. So we're, navigating those rules by going directly to them saying, can you please provide to us at the same time you're providing to government the form that would be available to us, unfortunately, after the proceedings. And this is our way of really adjusting for that 1-year lag in terms of the data that we see both in the RPIEs and that are available through commercial platforms, because even on a commercial platform, it's the FOIL rules. So they can't access something that has not become public. These forms become public in July when the final assessments occur. So this is, we would love to only use publicly available data that anyone could access, but this is our way to fill the gap. And again, I think what I've been encouraged by and appreciate the staff time and consideration is we're not presenting new trend lines here or new information. If anything, I think this real-time data shows unfortunately, that income has continued to decline and expense growth continues to ramp up.
Sorry.
No.
No, that's
And this is more, I think, your speculation or opinion, but when I look at this chart, the unregulated residential has a significantly greater drop during the period.
Yes, and that is a
What would
function
you-
of, yeah, I'm happy to explain that. Part of why I do not see as large a drop in stabilized apartments is because they are rent stabilized. We saw in the marketplace, we saw a lot of elasticity in the market that was not stabilized or subject to rent control. In some of these neighborhoods, as population left, rents dropped 40, 50%. You combine that with outstanding rental arrears. All of these things contribute to, I would say, the income that you're going to see from these buildings. So again, we talked about what is happening in core Manhattan. Is this a statistical anomaly? No, there's a lot of complicating factors for why we're seeing the rents where they are versus where they could be. What I took away from this is there's a lot of headlines about where market rate rents are or where rents are. They don't say these are the rents in fully market rate buildings that were built after 2000, right? That's not the headline. And I don't want to discount someone who's experienced, I would say, a rapid increase in their renewal if they are in an unregulated apartment. But when we start to cut through what's happening in the marketplace, and again, on a macro level, to not take away from an individual tenant's experience, on the macro level, we are seeing that unregulated rents have not recovered in a number of neighborhoods, and this is a function of how far those rents dropped in the height of the pandemic.
Great, thank you.
You're welcome.
One last question, and then Pasha will let you go. You list on the description of the categories in the TC 201 for expenses, fuel, labor, insurance, taxes, et cetera. Is part of the et cetera debt service?
So if we're comparing it to the RPIEs, debt service does not appear.
Okay.
So this has always been the challenge.
No, just if you're just looking within the TC 201s.
Yeah.
Whatever gets reported.
Yeah.
They do or do not report?
They do
sorry?
not. They
do not.
Just wanted to clarify that.
Do not.
Okay.
Yeah.
Great.
Which is our data challenge in these conversations.
Understood.
Yeah.
Great. Thank you very much.
You're welcome.
And finally, we'll hear from Ann Korchak from the Small Property Owners of New York. Ann, please take it
Thank
away.
you. So SPONY, the Small Property Owners of New York, is a 100% volunteer organization. We're primarily families that have been at this for generations. In my case, I'm helping my mother-in-law run 2 buildings that her parents bought in the 40s and the 60s, and that's very common among our membership. As our name says, we're small property owners. We're the people that are owning and operating smaller buildings, the overwhelming majority of which are both completely rent stabilized and between 6 and 20 units. Most of those members have buildings that are on the smaller side, 6 to 10 units, which poses an interesting situation because the RGB data, which already shows a severe and dire situation building owners are in, doesn't include the stabilized buildings that are less than 10, like the ones that my family owns. Yet your deliberations will directly impact these smaller buildings. So I'm here today to share on behalf of SPONY's diverse membership that the numbers and difficulties faced by owners citywide are actually much, much worse when you consider stabilized buildings in that small 6 to 10 range. Think about the buildings on the streets between the avenues in Upper Manhattan, the West Village, the Lower East Side, Park Slope, Bay Ridge, Prospect Heights and Crown Heights, Washington Heights, and Harlem. Think about the apartments that are above struggling retail on 9th and 10th Avenue in Manhattan or on Avenue U in Brooklyn. Think about the smaller 6, 7, and 8 unit buildings between larger buildings along the west side on 116th Street in Manhattan. Smaller buildings in Bushwick and Ridgewood, Sheepshead Bay, Sunnyside, and Maspeth. Every increased cost and every dollar in lost income has a more severe impact on smaller buildings. There's no economy of scale for smaller buildings. Smaller buildings cannot absorb the losses and costs detailed in the RGB reports. We cannot absorb the massive stresses we've experienced in our sector for the housing market, a 3-year pandemic, the cancel rent movement, and the lengthy eviction moratorium. We cannot absorb the total lack of access to housing court, which is where so many tenants are connected with the help that they need. We cannot absorb skyrocketing insurance costs, escalating energy prices, higher property taxes, and mixed rent. And the irony here is that we are not considered in the RGB data, but we are literally and physically the owners closest to the tenants. We're the ones closest to the ground, closest to the edge, and closest to insolvency. I agree with everything my owner colleagues have shared with you today, but to my testimony, I would just like to add the magnified hardship that smaller owners are facing in every neighborhood in New York City. And I thank you for your focus on the numbers, and just would add, the financial stability of these buildings, is in your hands. And I thank you, for everything you do. I know it's a very difficult job. Thank you.
Thank you, Ann. Let me open for any questions. Christina.
Thanks, Ann. That description, for me, brings it much clearer that, I wanted to kind of go back to what Michael was testifying about the 24/5 municipal requirements. When you take that huge expense and you put it on a building of the size that Ann's talking about, and the prices and the fines and the compliance requirements are exactly the same. So you could have a 150-unit rental building built after 2000 that has the same local law 11 requirements, maybe a little higher on the unit count because it's 10 or above on local law. But if you could just, I know you gave us the shortened version of those costs or those items, but if you could actually just enumerate.
Thank you for that question. Kelly and I have been spending the past couple of years actually trying to put dollar amounts, what we call the cost of compliance. It is very, very difficult to do. But I will, and I tried not to before, but I will very quickly list them for the record. I will list them by their local law name and then the 2-word description. Local Law 97, which is the Climate Mobilization Act, Local Law 152 of 2016, which is gas piping inspections, which has an enormous cost attached to it. Local Law 87, energy audits and retro commissioning. Local Law 84, benchmarking. Local Law 11, facade inspections. Local Law 55, mold and indoor allergens. Local Law 31, which is the XRF lead paint inspection. Local Law 1 of 2004, lead hazard reductions. Local Law 69, bedbug history. Local Law 10, Section 8 processing. Local Law 77, which is the regulation of cooling towers. Local Law 32, very much in the news these days with big costs, conversion to natural gas or electric, and then number 4 to number 2 heating oil. And then there are the compliance requirements that are not attached to local laws, but rather administrative or agency actions. Sanitation regulations requiring overtime to place trash out because of the new Department of Sanitation regulations, fire department safety notices, sprinkler inspections, recycling regulation costs, annual backflow prevention inspections, DEC oil tank registration fees, standpipe sprinkler coating, DHCR registration fees, code enforcement reinspection fees, third-party elevator inspections, and good luck getting an elevator service tech to actually come to a building. Lead paint certifications for workers in the building, and then DOF annual preparation of income and expense reports. So enumerating all these 24 took some time and took some effort for SPONY members, our SPONY colleagues that are often don't have the benefit of outside management agencies, companies, or have the financial wherewithal to contract with outside managers or professionals to do this. It falls squarely on their shoulders. And I would ask Ann to share, if it's not too personal, where she was right before coming to testify today.
Yeah, I did. I came right from the building. I was in the basement. That's why I still have my boots on. Yeah, it's very hands-on, you know, for the smaller owners. You know, I was there with 2 contractors, dealing with, you know, lead paint that we found on a door. You know, and for those of us that are, you know, conscientious and really trying to do the right thing, it's becoming increasingly difficult, you know, to, you know, keep track of that. I mean, that's why many of us, you know, belong to groups like RSA and CHIP, right, that they're constantly sharing kind of best practices with us and the different obligations that we have as an owner. And I just fear that, you know, the more and more complex that it gets, the fewer of us that will be able to remain in the market, and, you know, kind of the housing will change significantly in New York if, you know, all these tiny buildings, these 6, 7, you know, to 10 unit buildings are now just going to be owned by some institutional investor, and, you know, the tenants are going to have to call a 1-800 number in Texas to say, hey, there's a leak under my sink, you know, instead of, you know, texting me or sending me an email saying, hey, Ann, I have this problem. So it's going to change housing significantly.
Thanks, Ann. I had 2 questions. One is, I think, how many members are in SPONY?
How many can afford to pay their $95 a year dues? I mean, we're completely self-funded just with that. I would say our membership number is about 800, but, you know, so far only 300 people have been able to pay their dues this year. You know.
And then as a follow-up question, what's your reaction to when people say, well, the small business owners have the building, they own the building, they can always just sell it? Like, what's your reaction to that line of thinking?
I find it insulting. You know, this is our livelihood, this is our business, we've been at this for decades, right? There's a certain level of, you know, I'm married into this, you know, and I feel a commitment and a dedication to honor, you know, my husband's immigrant grandparents, you know, my in-laws who did this before us. So it's personal, so I find it very insulting. You know, that's, you know, do you tell, you know, somebody else who's running a business, go shut your restaurant? People feel bad when a restaurant closes. People don't care if a landlord has to sell. I mean, I don't think there's no parity. Like, why is that an acceptable thing to say to me, but not to another small business?
And I understand the huge burden all this puts on you as a small owner, but I think my question's more probably directed, Michael, to you. In that list of 24 regulations, which I would think we all would agree, well, maybe not all, but generally are a lot of regulations in New York, and we make it very complicated to do business in the city. But mine is more about the information associated with that. How much of those costs are not in the RPIE data, for example? Do you have any way of, I mean, I know you can't quite
I can't.
answer that directly,
I would
but.
love nothing more than
'cause-
to give an exact answer.
Yeah, no, but as I think about all those regulations and I understand them, almost everything would be an expense that somehow would be captured, no?
Not.
Not the capital. I understand the capital, if there's a capital upgrade requirement.
The capital
I
would
get the
not be
capital.
captured. I mean, how much of that is local law 97? How much of that is transitioning from oil to gas or gas
no,
to
no, no,
electric?
I get
mean,
that.
Those are the big costs that
The-
probably wouldn't be captured.
But
No,
is there a way to begin, I mean, again, this probably is not for now, and maybe that's what you're thinking of.
It has been a.
Down the road, to begin to try to think about how to capture some of those
We are
costs?
trying. We are trying. I would, something analogous, many, many years ago, the independent and private school and yeshiva and Catholic school community sued the state because there are requirements, administrative requirements that these schools have to do in order to maintain their parity administratively with public schools, traditional district schools. But a smaller Catholic school in wherever doesn't need to take attendance 4 times a day. They only need to take it twice a day. However, according to the regulations, they have to take it 4 times a day. They put a dollar amount to that administrative cost and sued the state. And the state, after many, many years of litigation, came back and said, we're not going to give you the $255 quadrillion that you're asking for, but here's $60 million and here's $90 million paid out over X. So yes, there are things that can be quantified, and nobody's editorializing about whether these are good or bad requirements. These are good requirements that need to be done for the health of the tenants and the buildings and the environment and the city. Absolutely, of course. There is a dollar amount attached, again, analogous to that schools comparison, a little clunky perhaps, but the school community said, we're going to put a dollar amount on the time it takes to do this. Is that analogous? Are we pursuing some sort of thinking like that? It's hard to do. We'd much rather say this is what the dollar amount is. It's not included in the PIOC. Please consider it in your deliberations. The capital isn't, but yes, some is. Basha, I'm sorry.
No, I think it's a really interesting question, and one I'd like us to continue engaging in on a staff level as a group. Part of how I've been thinking about it is it's certainly reflective in the rising insurance rates. In terms of when I think about insurance, the more litigation risk you have, the higher your insurance is going to be, right? Like, are you going to get sued because your basement keeps flooding because you happen to be in a floodplain, right? We see this all the time with the, I would say, the flood insurance conversation. I think similarly here, we're seeing it in the higher insurance rates. I think we see it in for those owners that can, this is where I'm interested in going on a data side, how many more people have they had to hire in order to do compliance? Because that is something we can capture on a salary and time level. We've engaged in that exercise actually on the housing lottery process, how much staff time is engaged in that process, how many staff hours are to, a single affordable apartment goes through the lottery and gets hundreds of applications, and the owner side of the housing lottery system is actually incredibly, you have to click on every window to get to the next window. There is no automation of any kind, and we calculate it, and it's that's an additional 3 days worth of time for an employee to process a single application. And then we see that 155 days is the average for getting someone placed into a lottery unit. So I think there are creative ways we can think about this to quantify it, because we have started, the City Hall itself has started to quantify the bureaucracy and compliance of some of the rules and processes it has. But again, I think the quickest answer is we see this in the insurance rates, and this is obviously a much more in-depth and complicated conversation.
And just to close out on that, just because some of those expenses can't be captured doesn't mean that the board can't make reasonable estimates of what those are and include them in some sort of analysis or deliberation. For example, the debt service. There's no reason the board can't take a reasonable percentage and assume that debt service is that number. Of course, there will be debt service that's higher, but that's a real cost, and taking a conservative estimate and including that in the data will, I think, give a better picture of sort of where building finances are.
One question. So when there is new compliance, is the city required to notify the owners? Or how do you guys find out about it? No, I'm saying,
Well,
like,
we,
is it?
we have, the
So
answer is.
that's
the
why
answer
we
is-
exist now.
Yeah, the answer is yes, ... We have professional staff and policy analysts and public affairs professionals that, when these regulations are first suggested, we, provide our responses in areas where we think it could be more efficient or more realistic or reflect the lived experience of our membership, and then they're finalized. There are those of us who wake up every morning and take a look at the city register and, see, we enjoy reading it. I'm not going to make a joke there. We enjoy reading it, and then part of what RSA does is with our membership, as I know Rebney does, and Sponey and Chip, is we educate our members and say, this is what is necessary, and you have to get this in by this time, and this is not a joke. And, for example, with Local Law 97, there's an incentive program for now, but at some point the incentives are going to turn to penalties, so better to do the low-hanging fruit. We spend the better part of our day on the other side of our office communicating with membership on the necessity of compliance.
But is the city required to notify owners? I guess that was,
Yes.
they are.
Yes, so the requirements are publication in the city register, a hearing notice. Some agency websites are designed to be more user-friendly than others. Again, part of our professional jobs are to monitor these websites and to monitor these notices and to monitor and receive these newsletters. This is not something that I think is accessible to everyday New Yorkers or smaller property owners. Even with the professional staff many of our owners have, with property managers, we still get calls on a daily basis. I just got a notice that this part of the local law was going into effect. Why didn't we do anything about it? And it's like, well, that local law was passed prior to my time at this organization, but also was passed 10 years ago and had a phased-in schedule that no one remembers, and the city does not have a requirement to send out a notice to all impacted property owners. And there's a lot of conversation about this because all of these notices have cost. Right, someone has to produce them and print them and mail them or post them, and a lot of times the owners are required to do the posting and noticing. That's usually always a requirement of any of these new laws, is that the owner must contact every single tenant. And now one of the most recent ones is to ask for a current phone number in case there is a fire emergency, to make sure that they have a phone number on file for every tenant. It's not a bad rule, it's just there's
Cost.
time and cost to that.
RSA every year designs and puts together a calendar, just a regular flip calendar that we find our membership and other organizations' membership loves, because we put deadlines and we do a 30-day look ahead, which is to say, on January 7th, you need to be thinking about this thing that has to be in March, and by beginning of March, if you want to contest your property tax assessment, it needs to be in, and in 30 days from now, you need to look at this. It is one of the most popular publications that RSA has, and if somebody moves or doesn't change their address, we hear about it because they haven't gotten their calendar. That's how seriously our membership, Sponey's membership, Chip's membership, takes these compliance issues, but every single one of these has a cost attached to it.
And I would just add that many of our board members, just in the local press, from, the city and city limits and, in the Daily News and the Post, we're following the elected officials, right? So just a week or two ago, Councilman Botcher announced a bill that had been introduced to expand the number of hours where the sanitation violations could be issued. Now it's, there's like a small window early in the day and late in the day. And while now it's just for commercial properties, we know, or the retail space and, maybe at the ground floor of a small apartment building, that it would, it's going to come to us next. So, I reached out to his office, and we had about a 45-minute conversation yesterday with him. He was, very grateful for the input. He and his chief of staff, like I said, spent 45 minutes in the middle of a busy day, to hear from us. And, that's what advocacy is, right? I mean, people have to, be on the lookout for something that may, cause them some heartache or difficulty. So that's what we all try to do.
All right, and let me thank you all again so much for the generosity of your time and for joining us. Thank you. Thank you. I think we have gotten through everything else we need to talk about, unless there's anything else anyone wants to raise. So could I have a motion to adjourn? And a second? Second.
There you
We are
go.
adjourned. Thank you very much.
Thank you.